Constitution started from an arrangement under which the legislature was approached for funding to finance victims, the payments of persons. And that is how the term, the language, supply originated. In the United Kingdom, they spoke of the Committee of Ways and Means, which is the committee that exercised their minds over how taxes would be raised to fund the activities. I mentioned that, Mr. Speaker, so that we understand that traditionally the executive has a whole range of things to do during the course of the year. However, there have been many instances where it carries out those activities, particularly placing imposts on the citizens without the approval of those citizens. And in the case of this entire region, including the North Americas, you had movements, even agitation in Guyana, which arose again in 1928 when our constitution was first, if you like, overthrown, resulting from the fact that the executive, often at those times not elected, sought to raise taxes at a time or in circumstances where the representatives of the majority did not have a say in how those taxes would be raised. And they ranged over a range of things. When the English didn't want the Americans to trade with Portuguese or with the Spaniards in the region, they would impose tariffs. And those tariffs would force citizens to purchase what would be cheaper options. If you would stop and listen, then you wouldn't bring city motions to us. It would allow what was ostensibly a free option, but it wasn't free because in fact you had stacked the cards by imposing taxes on commodities that came from outside of the United Kingdom itself. It is this concern over a minority and non-elected minority to determine the fiscal burdens of the populace that gave rise to the cry, no taxation without representation. There's a logic to that, Mr. Speaker, namely that the legislature is the place where the taxes to fund the supplies, the purchase of equipment, the purchase of materials, the funding of officials, that is where the legislature actually exercises the function. Because on a day-to-day basis, the operational things such as the purchases and so forth are done by the executive. The idea, therefore, that the executive would have the powers both to present an appropriation bill and to have it passed without modification, as Mr. Ramjikan pointed out, would actually degut the powers of the legislature. And there is no basis to argue that that actually exists anywhere in the Westminster system. The only place, and I had addressed this problem before, Mr. Speaker, I remind you, the issue was this. We receive estimates, proposals for both expenditures and revenues from the executive. The executive brings those proposals, and there are certain constraints on it already. They're already specified. We cannot, as indicated, we can't raise taxes. Okay? We can't add to the expenditures that are to be undertaken. These are the constraints. There are specific constraints drawn into all of those constitutions, and none of them includes an inability to amend the estimates other than in the manner that I have specified. Now, the case.
The honourable member is asking how many speakers. I had suggested that we have 2 from each party, then 2 each, but no one really. So I believe that the matter is sufficiently of import that we will allow. Attitude. I don't anticipate it will go on forever. I will allow persons who wish to speak. I don't expect we have a filibuster. I don't know, there seems to be something where Mr. Williams and Mr. Handilal are raising each other up. Honourable Member, please proceed my point. Go ahead, sir.
Thank you very much, Mr. Speaker. The process that I mentioned involving the Committee on Ways and Means, let me remind them, the only place, and this is not a national level, the only place where a legislature in this Westminster system is not given the option to amend the estimates when they are presented is within a system where, prior to the consideration by the Committee of Supply, which actually operates as a committee of the whole, there is another committee which considers the matter, that is a subcommittee of the House, which now exists in quite a number of countries. A subcommittee of the House looks at the matter and attempts to resolve the areas of difficulty. It is like an arbitration. In the case of an arbitration, therefore, if the sides have difficulty over elements in the estimates, they sit and hammer those difficulties out. They resolve the differences, and then they bring an agreed package to the House as a whole. When the House meeting as a Committee of Supply looks at the matter, the circumstances there would be, look, a lot of time was spent resolving these issues. They have now been resolved as in the case of an arbitration. If the House doesn't like it, the House's option are either to accept the changes because they are not big enough to break a lance over, or to reject them on the grounds that they breach objections that arose on one side or the other. Mr. Speaker, that means that the power of the House to examine and amend the budget is not removed. It is carried out at a stage prior to the Committee of Supply. A reserve package now comes to the House, and the House is not given the chance to consider the matter twice in terms of opening a matter that was already resolved. And as far as I'm concerned, those persons who argue, including the Attorney General, that this issue somewhere exists in the system of the Westminster system, whereby a House is not empowered to modify the estimates that come before it, is uninformed. It does not take into account that in the one case where that exists, it exists because there is a stage which we do not enjoy. We do not enjoy that prior stage. And if you were to say, this House cannot amend the estimates, we may as well go home. We may as well stay in the House.
Where is that one instance that you refer to?
I will find it and send it to you, Mr. Speaker. I believe it is one of the states most next year. That is, it's not a national piece of legislation, it's a state legislation. But what I'm saying, Mr. Speaker, is that in that instance, it provides an additional stage which that legislature enjoys, which we do not enjoy. If you remove that right from us, then we have only a talking shop here. We are only being prevailed upon to discuss the matter, even if we think a significant part of the proposal is unacceptable, then we are not at liberty to modify it. And that, Mr. Speaker, makes no sense whatsoever. Secondly, the distinguished minister made reference to the fact that the process in 2012, to which the Minister of the Attorney General objected, involved or was akin to his interpretation of the Chief Justice, was akin to this House making the submission itself. In fact, as you are aware, the estimates came to this House, the estimates were examined and amended. We then considered the appropriation bill. The minister reported to the House that the appropriation division. There was no division on that bill. Mr. Speaker, we have two sets of things we consider in this House, if I'm correct. You have motions and you have the formal legislation. As regards both, this House has always exercised the power which exists in Westminster system to modify bills which come before it.
Exactly.
Bills, whether they be bills in relation to originating on the side of the government, or whether they are bills arising in relation to private members. They have always had, we've always had the option of modifying them, and we have modified them where, we have amended them where necessary, especially when, of course, the bills are submitted in recent times by the government, and they didn't meet the approval of the majority. That is the principle. That is the principle of democracy in these legislatures. It is a majority that considers the submission, and they are at liberty to modify those submissions. And that is what we've done. So when the minister reported to the House that the bill had been approved as amended, having been considered by the cabinet and reached us via the cabinet, it is to me astonishing that the Attorney General could have brought a case against the minister and the cabinet and the speaker for carrying out a democratic process which they embraced at the time. And they are now seeking to overturn and create unsustainable practice.
We did have a president of Pereira. This House had unanimously passed a bill asking that ID card be made part of the framework for voting. And then that one side, in fact, was White, who was then in the opposition, and responded in that matter through his counsel to keep Messiah, and advance the argument that that act was unconstitutional, and on that basis the elections were shifted. So we do have precedent for something like that.
But
Go ahead.
Mr. Speaker, in the absence of any clear legal understanding of my term, I simply want to say to you that, to me,
it does cause laypersons especially to look at the law less favorably. Let me put it that way.
Thank you very much, Mr. Speaker.
There's a terminology that I want to repeat here.
I'll say no more. But
let us refrain from referring to each other's arguments as garbage. And I'd like to say something as well. Whenever there's going to be a reference to the Chief Justice of this country, let us make that reference with respect. Whether in a heckling manner or otherwise, it is the Chief Justice of this Republic, and no disparaging comments should be made of him or of any member of the court of this country. So let us bear that in mind. Go ahead, please.
Thank you very much, Mr. Speaker. I have no reference to make to the Chief Justice. I want to say that the examples that to which I was making reference, first of all, 1919, when the UK Parliament cut the budget submitted by the government, and more specifically, would you listen? More specifically, the allocation requested for the Lord Chancellor. That is the equivalent. Anyway. The point is this: that was cut, and the House had to live with it. Okay. Subsequently, in 1921, again, the traveling expenses of members was cut by the House. So traveling expenses were cut. These are two examples often cited. But let me say to you, Mr. Speaker, that as far as I have been able to ascertain, at least 128 cases of division have led to defeats by British governments in Parliament over financial bills or budgets themselves. So the idea that it is unprecedented that the House does not have the power to amend these bills is untrue. The evidence is to the contrary, and you can find. I can cite. I can give you the references. What I found, Mr. Speaker, is that the occasions after 1918, and it's interesting for us to understand, because when we hear about tyranny of the majority and the majority of one, we must understand that this is sin. Okay, a majority is a majority. Elsewhere, these majorities of one overthrow governments. Governments have resigned as a result of losses of only one vote. Democracy requires only that, a majority. Okay? So the thing is this, that since 1918, you've had defeats on financial bills arising mostly in the period 74 to 79 when you had a Callahan government. I don't know whether you are old enough to remember that, Mr. Speaker, but it was a very unstable. Thank you. It was a very unstable time within the United Kingdom, and many defeats, and I was there, and many defeats were suffered by the government. But the important thing is that the governments lost, and I'm making this point because it needs to be understood, Mr. Speaker, that the absence of government defeats over, or the amendment, if I put it that way, the absence of amendments to financial bills and budgets arises not as a result of an inbred principle in the British constitutions and the Westminster Constitution, but as a result of the exercise of the whip in relation to party powers in these countries. So the whip enforces the rule whether or not MPs agree with them. But you will recall even in recent times, Mr. Speaker, that the experience of a number of governments, including the government, the Thatcher and the post-Thatcher government, has been that you've had backbench rebellions. The backbench rebellions in which the government MPs themselves object to the content, the substance of the bill presented by the government. Fortunately for the countries there, the government is wise enough, have been wise enough in most instances to suspend the consideration of the bills, modify them, take into account the demands of their backbenchers. What I'm saying, Mr. Speaker, is that there are a number of circumstances. One is the backbenchers may rebel. They may be unanticipated absences in relation to the two sides of the House and a number of other things. Those factors have led to at least 128 cases of amendments to financial bills, including budgets, tax measures, expenditure measures, and the like. So our colleagues must not come here and tell us, Mr. Speaker, and tell us that that does not happen or that it is not permitted under the dispensation under which we operate, because that is inaccurate. It is inaccurate. Okay? As far as I'm aware, the Lord Chancellor, as I mentioned earlier, is an office within the United Kingdom. It is the most senior legal officers there, and if the AG is not aware of that, then I think that is I hope he now knows. What I'm saying, Mr. Speaker, is that we have the power as a House to amend bills that come to us. We have the power to amend an appropriation bill because it is another bill. It is just the character of the bill, but it is like any other bill, and we have the power to amend it. And without the power to amend those bills that come to us, we have practically no powers at all. And as I mentioned earlier, we may as well send out an email and ask members to respond by round robin because they have no decision to make. The idea of a debate here is to enable us to inform any changes that we have in mind, not whether or not you vote. So these are the points I wanted to bring to the House's attention, Mr. Speaker, namely that there is precedence for it, namely that the government itself was party, the executive rather, was party to the process it was the representative of the government by the Minister of Finance who submitted to the House, on the House's behalf, the appropriation bill as approved, as amended, without a division, and therefore it is quite out of order for them to come now and suggest that in principle this was a problem. Thank you very much.
Take a break or something, but if there's anyone else who...
If there are no others, I wish to respond.
This,
If there are no others,
I suspect there are others.
okay.
I know the government chief whip rising, you wish to address the House, Mr. Chair.
To tell you the truth, sir, we didn't recognize this. As a parliament, even though we had two special select committees and a consultant come from the Trinidadian Parliament, because I believe no one anticipated there would be such a situation where cuts would have actually happened. And we learn, sir, as we go forward. The British Parliament started in, what was it, 1100? It is now over 1,000 years old, and the British Parliament is replete, the House of Commons House is replete with the many experiences and changes they've had to make as time has gone on. Our Parliament is a young one. I believe I saw something in the newspapers about this. But Mr. Speaker, there's some things I think we have to underline in this discussion. One, system of a first past the post system as distinct from a PR system. The second thing is that we have a hybrid Westminster Republican system, not a Westminster system. We have a hybrid system that has many aspects that are Republican in it. Thirdly, sir, that we are governed by a constitution, and the constitution is the supreme law of the land. And therefore, we're different from a number of countries that either don't have constitutions or have made parliament the supreme, given that supremacy. But Mr. Speaker, too, in the discussions here today, the underlying issue of all parliaments, of all governments, of all oppositions, are that it is the constitutional and prerogative of the executive, whether in the form of the Crown, as in the British Parliament, in the form in the Canadian Parliament of, again, the Crown, and through the instrument of the Prime Minister in Canada, or whether it's Australia or India or so on, it is the prerogative to bring the estimates, bring the budget, request money based on its overriding responsibility and duty to manage and guide the finances and the management of the country. No one disputes that. However, budgets are not created by just putting a bunch of numbers together, sir. They're interlinked and interlocked. The fact that words have been used in this parliament, the Chief Justice ruling, sir, just let me stop for a minute, pause for a minute. The Chief Justice ruling, when you read it, is a very, very interesting document and very enlightening document, because he makes the difference between parliaments and constitutions that have allowed for parliaments to determine and to approve or disapprove, and parliaments which have not. And he points to the Australian Parliament where such powers have not been conferred. And he quotes from the British Australian case. But sir, we talk about the power to cut. The Chief Justice talks about to approve or disapprove. And the Standing Order 76, which the Honourable Member Rambutan and the Honourable Member Mr. Greenwich have quoted from, in 76(7, says an amendment to leave out a head shall not be in order and shall not be placed in the notice paper. Sir, in the motion submitted by the Honourable Member, there is a submission, there are submissions to cut heads, to reduce heads to 0. Those particular submissions by the member need to be segregated. And why I believe the Standing Order says this, sir, And when you go to Erskine Mays and you go to the constitutional unit of the Commonwealth, and you and I have shared that document, sir, from the University College of London, the study of minority governments in a number of countries, in which the rule of thumb to do with the prerogative of the executive to bring the budget, and the prerogative to scrutinize, to challenge, to question, to interrogate the government on the use of funds and on its proposals. But it does not mean that it is giving the power to reduce. It is giving the power to approve or disapprove. So we're talking about Mr. Rambutan's motion. There are some of these motions that are actually irrelevant because in fact it only requires, because they're heads, and when they come to the vote, they want to object. The heads that you would be removing money entirely and coming to zero. What the honourable member, Mr. Rambutan, is saying is that we really don't want to reduce to zero in some cases, but we want to cut. And the Chief Justice ruling is that this Parliament, this opposition, the opposition as guided by the Constitution, does not have such powers. If we want to go in that direction, we have to amend the Constitution, but it cannot be done by a sleight of hand, by bringing a motion to reduce the head or subhead under the budget. Mr. Speaker, I remember last 2012, we started some of these discussions, and we started some of these issues in the last Parliament, in the last 2012. And there were very strong views, and the government decided to approach the courts. It is rather facile, I believe, and a little bit mean-spirited. It's scoring points, but we're in Parliament, so we try to score points. But in 2012, April the 17th, 18th, 19th to the 26th, we were in uncharted waters as we are now. And the cuts that came about and the reduction of the budget by 19, almost 20 billion, was totally new. It never happened in this Parliament from the time of which it was formed. It never happened since there was a cabinet, and I saw a newspaper in Ghana review in one of the papers about the cabinet system being introduced, etc., in the anniversary of it. That's never happened. We were confronted with a brand new situation in which the only guide we have, the only thing we have is the Constitution. The standing orders have not been amended by our own fault, by a human error of not bringing the standing orders into compliance with the constitutional amendments and the Constitution. But sir, the comments made by members on the other side that we're taking away